Appeal in the 4th, 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you, Mr. Marshall. Good morning. Good morning. Welcome to another oral argument session of the 5th District Court of Appeal. It is Tuesday, February 7, 2023. As our marshal just indicated, I am Judge Lambert, Chief Judge presently. I'm presiding over the oral arguments this morning. We have 3 cases. Let me introduce the panel for you, and hopefully we have the name tags in the right spot. To my right and to your left is Judge Scott Maker. He is recently with the first ECA and came over here as part of the realignment. And we're very pleased to have Judge Maker with us on the court. Great addition to our bench. I guess I'll have to say nice things about this guy to my left. This is Judge John Harris. His dad was very smart. He was a former judge here on our court. And John has a very good legacy following his father's footsteps. Probably the nicest thing I ever said about him. Not his dad, but him. All right. A couple things today. Each side will have 20 minutes for oral argument. The appellant, we will reserve 5 minutes for rebuttal. If you would like more or less time in rebuttal, please let me know, and I will adjust the clock accordingly. What will happen when you're into your rebuttal time, you will see a yellow light flashing. At that point, that doesn't mean you have to stop. That just is putting you on notice. If you want to keep going, keep going. You don't get any extra time. But if you want to stop, just let me know, and we will reserve the rest of the time at that point. When you get past your 20 minutes, you will see a red light flash. At that point, please, if you've not already concluded or if you're not concluding, please begin to conclude, and I will keep an eye on that so that we can bring this to a conclusion. Also, we are being recorded on YouTube, so please keep that in mind. People may be watching you or can watch you in the future about what you say, so just keep that in mind. And if you have any type of electronic device, phone, whatever, please put that in either the off position or the mute position so that it doesn't inadvertently go off during the oral argument and distract either you or your opposing counsel or the court. Okay, those are all the preliminaries. All right, our first case, 22-1241, HERC, H-E-R-C Rentals, Inc. versus Superior Site Services, Inc. and Chad D. Lee. So, counsel, if you're ready, come on up.
Chief Judge, Your Honors, may it please the court.
Yep.
My name is Drew Peeler, and I represent the appellant, HERC Rentals Incorporated, in this appeal. And the 5 minutes that you already reserved for me for rebuttal is fine.
Okay.
There are 2 issues before the court today. First, whether the credit application and guarantee, which form the entirety of
Can I just jump in? You raised 3 issues in your brief. Are you waiving one of those 3?
Your Honor, the second issue was broken up into 2 issues in our brief. The first part, whether or not the contractual interest was applied to the undisputed invoices, and I believe the third was whether or not it was applied to all of the invoices. For purposes of this oral argument, I'm going to address both of those.
Okay, I just want to make sure I was clear. Go ahead.
Your Honor, the first issue is whether the credit application and guarantee, which formed the entirety of the business relationship between HERC and the appellee Superior Site Services, Inc., was still enforceable at the time of the rentals by Superior Site Services. And the second issue is whether the contractual interest rate set forth in both the credit application and the rental agreements applied to the rentals at issue in this case.
Well, it wasn't called a contractual interest rate. It was called a late fee, wasn't it?
Your Honor, it was referred...
Those are the specific words that are used in the agreement, right?
Yes, in either the rental agreement or the credit application, I believe it was the rental agreement, it referred to the as a late fee. However, it's laid out as a contractual interest rate. It says that they can apply the maximum rate allowed by law. And in the credit application, it does, I believe, refer to it as an interest rate. That's on page 557 of the record, and it's in paragraph 6.
Judge Alley didn't see it as interest, right? She saw it as a late fee. Either or. She said, if I don't pay my credit card, I get a late fee. and I get interest charged.
Your Honor, there was some discussion during closing argument about whether or not it was a late fee or an interest, but during her judgment, she made no distinction between the two, and appellant would put forth that this was error because this was in, not only was the credit application continuing in nature, which I'll get to when I address the first issue, but also in, like you said, paragraph 13 of the rental agreement, there was the late fee.
Do you think that issue is sufficiently preserved for us? And I mean, there's a body of law in the appellate world that basically puts the burden on the appellant to explain why it is that they believe the trial court erred. And if I'm looking at the one paragraph in issue 2 of how you've couched your brief, is basically you're saying this is really prejudgment interest. It's not a late fee. And you cite to a couple of subsections in the usury statute, chapter 687, in support. And so I went and looked at those subsections, and how is that sufficient to allow us to proceed to grant relief if relief is otherwise justified?
Well, Your Honor, for 2 reasons. First, the policy behind the rule of that appellate body of law that you mentioned, which is outlined by the Supreme Court in Sunset Harbor Condominium Association versus Robbins, which states that in order to preserve for further review by a higher court, an issue must be presented to the lower court and the specified legal argument or grounds to be argued.
It's not that. I'm talking about here now. I mean, you can't, in other words, you can't just write a brief and say, judge was wrong, please reverse, and I should win. I mean, obviously that's a little simplistic, but I mean, that's the whole reason behind some of the case law that says, you know, you need to fully brief it and not just say, go look at the statute and that's why the judge was wrong.
Well, Your Honor, I believe...
I know you didn't write the brief, so I'll give you that.
Your Honor, I don't believe that the argument is necessitated upon those 2 statutes that you mentioned. I believe, as I'll outline in the oral argument as regarding the second issue, that appellant's argument is successful either way. And that's partially because the lower court found an assumption of dealing or under a course of dealing which allowed for attorney's fees pursuant to paragraph 7 of the rental agreements, and an example of which can be found on page 565 of the record. But inexplicably found that interest or late fee, if you'd like to call it that way, did not apply.
That's what your contract calls. I mean, I'm looking at R557. It says we'll pay a late fee of X amount of dollar or whatever, and then it talks about late fee. You know, go ahead.
Well, Your Honor, I think I might be able to better address this by talking about the first issue because...
Go ahead, talk about the first issue.
All right. Well, the reason I want to talk about the first issue is because in the credit application, there's also an interest provision. It's paragraph 6, and again, that's page 557 of the record, and it states, I believe, 1.8% contractual interest monthly or the maximum amount allowed by law.
Pay a late fee to HERC on delinquent invoice until fully paid at 1.8% per month maximum, or otherwise is permitted maximum rate by law. So again, you're not helping the argument to me because it doesn't say interest, it says late fee.
Your Honor, regardless of whether it says interest or late fee, it's still a term of the contract that would apply to all of the rentals.
Right, and the judge found that the late fees were waived, and you're not challenging that here. You're saying she just called it the wrong thing. You're not saying, hey, I get late fees plus interest, and the judge said we waive late fees, and all that was part of the negotiation, and it shouldn't have been a bar to the late fee.
Your Honor, there was discussion during closing arguments about whether or not they've been waived, but I do not believe in her actual ruling, which begins on page 275 of the trial transcript, that she said that it was waived, specifically only that it didn't apply. However, the discussion about it being waived centered on the corporate representative for her, Kyle Boley's testimony, and about whether or not the 999 invoices, which were internal and written off for their own purposes, and which were presented at a previous point in time as far as negotiations about whether or not, okay, well, maybe we will write off the interest if you go ahead and pay us the principal amount that's due. However, that doesn't mean that they're not entitled to pursue those those late fees or those interest rates, and they did so, and it was properly pled in the pleadings. And Your Honor, as to the first issue about the credit application and the guarantee, the court found that the credit application is the contract which forms the entirety of the business relationship between the parties. Yet, it also ruled that it was not a contract any longer, and therefore the guarantee within it is also not enforceable. This is incorrect because the credit, for several reasons. First, the credit application states without restriction or time limitation that rentals made subsequent to the credit application will be governed by it. That's paragraph 1 of the terms and conditions on page 557 of the record. And second, the guarantee expressly states in the second sentence on the bottom half of that same page that it is a continuing guarantee. And additionally, under Florida law, the guarantee fits all 3 possible criteria for a continuing guarantee as laid out by the 3rd District Court of Appeal in Fidelity National Bank of South Miami versus Mello. Of those 3 criteria, the guarantee need only fit 1, and those 3 criteria are, first, that it contemplates a future course of dealing during an indefinite period. Second, that it is intended to cover a series of transactions or successions of credit. Or third, the purpose is to give the principal debtor a standing credit to be used from time to time. And in this case, even though it needs to only meet 1, the guarantee on page 557 of the record that's at issue here meets all 3 of those categories. Therefore, there's no question that the...
Well, I mean, it's your opponent's position seems to be, okay, we had that, that's fine. I paid all those bills were paid, the company stopped, and then years later, we started up again, there's a different company, and we have these transactions. I never signed a new guarantee, so why am I, and I get it where it becomes a little fuzzy, is that quote, I'll use new in quotes, the new company has basically the same name as the entity for which the guarantee was signed by Mr. Lee. What if the new company said, I'm Big Dog Bulldozing Inc., and they want to rent stuff from Herc, but it's Mr. Lee as the owner of that company? I mean, would the guarantee in your mind still apply then?
Yes, Your Honor, and that's for 2 reasons. 1, paragraph 14 of the credit application specifically states that it's the undersigned's responsibility, in this case Chad Lee, to inform Herc of any change in ownership structure, identity, or anything that may have any effect.
I don't change the ownership structure. That entity is long gone. It's dissolved. It's dead, whatever you want to call it. Now, years later, I've started a new company, and I'm renting from Herc, and Herc rents it to me. They mistakenly believe I have a guarantee for the new company, but I never did. It's not changed. It's not changed form. It's a new company.
Well, Your Honor, that would certainly matter if the trial court found that this credit application applied only to C. Lee Inc. However, the judge did not find this in the ruling, and even if it did, that would certainly be error because if you look at the record, at the time of the agreement in 2006, the appellees were the only persons or entities legally using the name Superior Site Services. The fictitious name for Sealy Inc. was not registered until 2007, and that's on page 593 through 95 of the record.
Right, but the owner of the fictitious name starting in 2003 was Mr. Lee himself, right?
Yes, Your Honor.
And then in 2005, Inc. was incorporated. Superior Site Services, Inc. was incorporated.
Correct,
right?
Your Honor.
And then 2006, there's still the Superior Site Services is still in existence as a fictitious name with Mr. Lee, right?
That's correct, Your Honor.
All right, so, and that's who he signed, that's who signs the agreement. So, and that entity eventually disappears, right?
Yes, Your Honor.
Okay, and so Mr. Lee convinced the trial judge, and you have to convince us why the trial judge was wrong. Mr. Lee says, well, that entity ended. And years later, we started, we have these transactions with Herc, which is the subject of this litigation now, but that guaranteed contract, there was nothing for me to say that we changed form because that company is defunct, deceased.
Well, Your Honor, I don't believe that the trial court actually did find that was specifically
said
only...
it expired, right?
It said, yes, Your Honor, it said that it had expired in essential words. However, it can expire because the guarantee is continuing in nature. And in this instance, the appellee himself testified, I believe it's on pages 167 through 169 of the trial transcript, that he never terminated the credit application, he never revoked the guarantee, and then he further testified, excuse me, that's on 174 and 75. On 167 is where he testified that he held both companies out as superior site services. So essentially, this ruling would allow him to pick and choose, well, okay, I'm doing business now. At the time, I wished for you to do business with both of my companies, or I intended for you to do business with me, and I was going to do it under one of my two companies. And then years later, if the guarantees found no longer to apply because he said, oh, well, the company that you were really doing business with back then, which Herc would have never known, stopped doing business in 2011. And, but anyway, there's no question that the guarantee is in fact continuing in nature. And this remains in effect under Florida law as the 4th DCA laid out in Causeway Lumber versus King, that it remains in place until it's revoked. And that's important because Mr. Lee testified that he did not notify Herc of the guarantee, and this court in 4th DCA further went on to say that it's the guarantor's responsibility to revoke that guarantee. And this is necessary, Your Honor, because in cases such as this, where a company like Herc extends credit in reliance on that personal guarantee, they should be afforded the opportunity to reevaluate whether they would like to continue to extend credit under the same terms, or whether they would like to continue to extend credit at all. And here, because Mr. Lee did not notify them, as was his job under paragraph 14 of the credit application, that there was any sort of change in business, or that the company was doing business with Sealy Inc. before, but now is doing business with Superior Site Services, and because he never notified them that he revoked the guarantee that applied to the account, then Herc never got that opportunity to protect its own interests by reevaluating the credit application. Your Honor, appellant believes...
If I can interrupt, is it your client's business practice to always have a guarantee?
Your Honor, typically they seek the guarantee. There was some testimony regarding that, I do believe, during Kyle Boley's direct examination. But the credit what usually happens is they send out a guarantee, and if it's executed, then they use that information to decide whether or not they want to extend credit. And if the guarantee comes back unsigned, then at that point, they evaluate whether or not the company is creditworthy enough on its own without the guarantee to continue extending credit. And here they had a guarantee, so they're entitled to use that information and his personal credit in order to make decisions about who to extend credit to. And the credit application is very specific about, and especially in paragraph 14, about the specific account with Herc. And if your honors look at any of the rental agreements in the record, again, there's one, I believe, on 565, and the credit application itself, which I believe is on page 55 of the record, all of these are under the same account number. And the credit application terms are very clear about the account is not only what the credit application terms apply to, but also what the guarantee is in place to guarantee for. And I see that I'm about 5 minutes, so if it pleases the court, I'm going to go ahead and reserve the rest of this time for rebuttal. Thank you.
All right, counsel, Mr. Ludwig.
Thank you, Your Honor. May it please the court, Eric W. Ludwig for the appellees, Superior Site Services, Inc., and Chad Lee. I think the key issue here, as I said in a very brief, is whether this credit application and the written guarantee apply to subsequent dealings years later with a separate corporation. It is very clear from the record and all of the testimony that the original credit application contemplated that it was with a corporation, and the testimony by Mr. Bowley on behalf of Herc at the trial was that they did a corporate record check on that application. That application was on behalf of Sealy Inc. doing business as Superior Site Services. And then they ran into, as you are all aware, this confusion about the ownership of the fictitious name and all those other issues. But Superior Site Services, Inc. was a separate corporation run by Chad Lee's cousin.
Chad Lee was the quote owner and the
He was
president,
the president of the corporation. It was
sole
being,
board of the director, sole member of the board.
it was being managed by his cousin, and he was not participating in the operation of that company at that time. He took over operation of that company in 2014 after the C. Lee E. Inc. business with Herc had been completed in 2008 or 9. It wasn't real clear what the final date was, but in 2009, C. Lee Inc. was dissolved.
It was administratively dissolved in 2011. According to the records admitted in evidence.
Okay, I had a note that it was 2009, but in
I
either
mean,
case.
basically, it started in 2003. Superior Site Service was a fictitious name owned by Mr. Lee personally.
Correct.
All right, then in 2005, Superior Site Services, Inc. is incorporated. 2006, we have the contract with the guarantee at issue. In 2007, Mr. Lee then changes the ownership of the fictitious name from him personally to C. Lee Inc. But he testifies that basically all during this time he's using Superior Site Service, the name, for both the Inc. and C. Lee Inc. at the time. He says that.
That's correct, and they were doing separate types of business. One was a commercial.
They were doing the same
site
business.
service, and one was.
It wasn't a florist shop and building houses.
No,
They're both doing the same thing. One entity was for residential, one was commercial, and he wanted to use the name to the Superior Site Services for both to kind of build business. I think that's his
Correct,
testimony.
Your Honor.
All right, so.
No question about that.
So he's holding out that his entities, regardless of who, quote, the manager is, his entities that he owns are working under the label of Superior Site Services.
Correct, Your Honor.
That's a fair interpretation of the evidence. That's uncontradicted.
But
Your guy said it.
Right,
Okay.
the contract itself and guarantee was in the name of, well, Chad Lee signed the guarantee, but the original credit application was in the name of C. Lee Inc.
And it seems to me the question, and correct me if I'm wrong, is all right, like we have this other entity, then there's a 4 or 5 year lapse of time before business starts, Superior Site Services, Inc. starts doing business with Herc, right, 2015 or so?
Correct. They were, Chad Lee took over the active management of Superior Site Services, Inc. in 2015, and he was approached by Mr. Pacheco, and
Right, they get back and doing business with Herc in
Right.
2015 after a period of time of no business apparently with Superior Site.
approximately 6 years of no business whatsoever between the two.
And it seems that gap is significant to you and/or the trial court. And again, correct me if I'm wrong, but let me change the facts a little bit. Let's go back to, all right, Mr. Lee is operating both businesses. He's the owner of both businesses. He has a guarantee, nobody disputes that, for Superior Site Services, the fictitious name. We'll go that route. All right, so he pays all the bills that are owed to Herc. The company, let's say he dissolves the company the next day. He didn't know, Chad Lee Inc. is now dissolved. And then the following day, he starts being more active with Superior Site Services Inc., and he starts renting, he's renting equipment again with Herc. So now we don't have a 6-year gap, we have a 1 week gap. And so Herc continues doing business with Mr. Lee, sees the bills are being sent to Superior Site Services. Mr. Lee never says, oh, by the way, just so you're clear, I've dissolved that entity that had the fictitious name and I'm now working as Inc. He never does that. It seems to me your position would still be, well, you know what? If Inc. doesn't pay any of these new bills that they started incurring a week after the fictitious name was gone, that the guarantee doesn't apply. Am I following the argument?
That argument could be made. It's a much more difficult argument to make
Admittedly.
when it's
Yeah.
essentially simultaneous. The problem we have here is...
That's my point. What's the time frame? It seems significant. I mean, the judge says it expires. Under my hypothetical, it sounds like it expired. It expired, one Friday, then the next Friday, he's doing business again with Inc., and it's the same Chad Lee, same fella or person at Herc, and they're continuing on, and Herc's not been notified that, oh, by the way, there's an Inc. on the ad of the name, at the end of the name, and they believe they have a guarantee, and then lo and behold, 2 years later in litigation, they are faced with this defense saying, no, you were dealing with a different entity, even though it's the same human being and they do the same business. So my question is, why is the time frame significant when your client had the affirmative duty to say, hey, by the way, not for nothing, services is no longer in existence. I don't think my guarantee applies. I'd still like to do business with you. And then Herc can, they can take whatever steps they choose to take or not.
Well, in this case, the credit application was the name of, it said Superior Site Services in the name, but it identified the corporation, and the testimony was, and the sole evidence at trial was, that all payments made were made by C. Lee Inc., DBA Superior Site Services, up until the time C. Lee Inc. ultimately went out of business. The 6-year time frame shows the difference between the people he was dealing with in 2003, 4, 5, 6, 7, 8, and the people who came to see him 6 years later.
And again, that seems to be dispositive, or in your view, in the trial. So if it was a month later, it would seem you would have to be making the same argument, saying
we would be making the same argument, and it's our position, Your Honor, that in this particular case, the trial court found in favor of the argument, primarily, I think, because of the lapse of time, and made its ruling.
But if it's based on, if these are the facts that are undisputed, then does it become a question of law, or whether there's competent substantial evidence to support the ruling?
I think, Your Honor, that...
Well, I know which one you should pick,
yeah,
but go ahead.
We believe that the judge heard the evidence, the judge observed the testimony. The plaintiff, appellant in this case, didn't call Mr. Pacheco or any of the people involved in the 2015 approach to Mr. Lee at the new physical location with the new corporation to counter it, and the trial court made its finding, and we believe that that finding is supported and it should not be overturned because of the...
Was Herc made aware by Mr. Lee that the services, the fictitious name, had gone away by the time of 2015?
That's not clear, Your Honor. It's not in... I can't tell from the record, and I can't represent to the court one way or another.
So he wasn't asked, oh, by the way, did you tell anybody about whether the services is no longer in effect and it's a corporate name that's different?
I don't know, Your Honor. It's not in the record, but it is clear from the record that Herc was paid by C. Lee Inc., DBA, Superior Site Services, prior to 2009, and from 2015 thereafter, they were paid by Superior Site Services, Inc.
Oh, because C. Lee Inc. was no longer in existence, so...
Correct, Your Honor. And there was a 6-year gap.
Well, counsel, if I can interrupt, if the relationship between the parties is governed by a document, which document is that? I think you all agree that the original rental agreement, the credit application, and so forth, the terms of that still apply here, don't they, between the parties in the 2016, 2015 transactions?
I don't think so, Your Honor. I think that the agreement signed in 2006 governed the relationship with C. Lee Inc. through 2008 or 9 when they ceased business and were paid in full.
Okay, then my question is, what document governed the other transactions?
Invoices for the equipment which was rented over the period of time after 2015 would govern the subsequent dealings.
Okay, so your view is this document that was originally signed is a nullity in its entirety?
It doesn't relate to Superior Site Services, Inc.
It expired, according to the trial judge.
I'm sorry?
It expired
Well, that's
according to
the
the
term
trial
that
judge?
the court.
I'm not
used, yes,
being
Your Honor.
dismissed, that's what the judge said.
Yes, Your
That
Honor.
she found it expired.
Well, did she say the entire agreement expired or the guarantee had expired?
I think both, Your Honor. The agreement was with Sealy Inc., doing business as Superior Site Services. And we have a new corporate entity doing business as Superior Site Services and using that name directly.
She said the credit agreement is not a contract anymore, and therefore the guarantee that is within it is also not enforceable. So there, if I'm understanding how you just responded, Judge Maker, the 2015-16 transactions, there wasn't a set, there was just invoices being sent, and that's
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 correct, Your
how
Honor.
your client knew that, how Inc. knew that it had some obligation to HERC?
That's correct, Your Honor.
No separate, oh, by the way, here's an application, I'm a brand-new entity, I want to get some credit through HERC?
That's correct, Your Honor.
Because
The
HERC apparently
testimony-
thought that the old agreement was still in place.
Well, Herc may have believed that. Mr. Pacheco, as the evidence was, and the unrefuted evidence was, Mr. Pacheco came to Mr. Lee and said, why don't you do business with us? And they actually negotiated some slightly different terms. One of the terms that Mr. Lee thought was important was that the billing cycle was 30 days instead of, I think, 28, but in any event, there were a couple of different changes that were negotiated pursuant to the testimony with Mr. Pacheco.
Didn't HERC use the same business account?
I think the same account number was used on the invoices, Your Honor.
Right, so it was basically a continuation of the agreement in that regard, or at least the relationship in that regard.
That appears to be the way that Herc was treating this matter, yes, Your Honor. And I can't dispute that. Mr. Lee did not ever testify that he had recognized that as a same account number that had been used 6 years earlier.
And there was never any testimony that, hey, we'll just do business like before. In other words, was there any testimony in the record that said, we're just going to continue business like we did before?
There was no testimony like that at all. What testimony there was that the billing cycle would change and that Herc would maintain the equipment on site, which was not a condition of what was done previously.
Let me just off a different topic. The judge awarded attorney fees related to I think what she referred to as the agreed upon invoices, but then awarded $4,117 or whatever for the trailer, but no fees. Why was that? What's the explanation on the record for that?
Your Honor, I can't answer why the court did what it did.
I mean, isn't it all the same events occurring? Why is the trailer parceled out?
Well, the issue with the trailer was that Mr. Lee testified that the trailer was loaned to them while their trailer had to be repaired. And the court found that that may have been the case initially, but then when Herc started invoicing over a period of time, she awarded damages for the trailer.
So it went from a loan to a lease based upon the invoicing?
Apparently, the court treated that. She said specifically that once Herc continued to invoice for it, it was no longer a loan. And that was a conclusion.
It was a leased thing, and then it was like the other two entity, the other, trucks or what have you?
Yes, Your Honor.
Okay, that seems interesting. Go ahead. Well, I was trying to glean through how that parceled it out, and I wasn't sure why. And you were well, he wasn't, but I mean, you and the appellant's brief writer were the trial lawyer, so I was just curious as to maybe
I think that we're in a situation where the trial court made a finding based on hearing the evidence, and that.
Well, yeah, I mean, but that's what trial judges do. I'd be curious, but just curious as to where that came from. I mean, I know she sat there and heard it, and I know she wrote stuff down, and that's what somebody's unhappy about, what she wrote down, and that's why we're here. But I was just curious as to what the evidentiary basis was for saying trailer's different than the other things, the other two pieces of equipment.
I think that all rested on the testimony from Mr. Lee that the trailer was a loan to replace the company's trailer that was being replaced.
But then it
or
was,
repaired.
then there was invoiced as if it was a lease thing, of which she considered it, and she awarded, all right, go ahead, that's neither here nor there. Go ahead.
I have nothing further, Your Honor. I believe that the trial court made her decision, and that the facts and the documents and the evidence before the court is not clearly erroneous, and that the findings and final judgment entered by the court should be sustained.
All right, thank you, counsel.
Thank you.
Okay, Mr. Peeler, looks like you saved yourself 4 minutes and 55 seconds, so you can use all or as much of that as you like.
Yes, Your Honor. All right, may it please the court?
Yes, sir.
Appellant has just a couple points on rebuttal. One, I'd like to start by answering Chief Justice
Not the
Lambert's-
Chief Justice,
Sorry,
and
Chief
don't want
Judge.
to be either.
Excuse me.
Chief Judge, that's fine.
Chief Judge's question about whether or not he ever
All due
notified
respect to
Superior.
Chief Justice Muniz. Go
And
ahead.
I'm on the bottom of page 174 of the trial transcript. It says, "You never notified Herc Reynolds that Sealy Inc. was using the fictitious name Superior Site Services, correct?" And then at the top of the next page, the answer is no, ma'am. And the follow-up question is, "And you never notified Herc Reynolds of your revocation of a personal guarantee, is that correct?" He asked if you could ask the question again. She said, "Did you ever notify Herc Reynolds that you had revoked the personal guarantee that's attached to the Exhibit 1 credit application?" He said, "No, ma'am." Attorney for Appellee, he suggested that the credit application identified Sealy Inc. However, that's incorrect. The only name on there is Superior Site Services. And if you look at the record, it's clear, and there was a lot of discourse about this, that the federal taxpayer ID, which supposedly would have identified Sealy Inc., is incomplete. And so the only thing that Herc had to identify who it was in contract with was the name Superior Site Services.
Well, there is no actually mention of C. Lee Inc. in the credit app and the guarantee, et cetera. It's just Mr. Lee himself.
Correct, Your Honor. And so in 2006, when Herc entered into this agreement, all it had to go by was Superior Site Services, and registered that fictitious name was Chad Lee. And then there was also in existence Superior Site Services, Inc., which would have come up on a corporate record check with Chad Lee as an incorporator. Sealy Inc. didn't have the fictitious name until 2007. Again, that's on the record at page 593. And the fact that Sealy Inc. was the payer on some of the original invoices is irrelevant to who the parties to the agreement were in 2006. The payor, especially when the appellee admitted that he's holding both companies out as the same, could have been either one, and it's irrelevant to who the actual parties were. And, oh, sorry, I thought you said something.
Well, counsel, what is your best evidence that the agreement continued forward? In other words, was there testimony that the parties agreed that it was going to apply? I mean, it seems like your best argument is that, well, this agreement said that it will be continuous. I mean, I'm looking really for, because it looks to me like there's evidence on both sides on this issue, and if that's the case, then I think you're in a difficult spot.
Well, Your Honor, the best evidence is that he held both companies out, and that the credit application, it says at the top in paragraph 1, I believe the language is that all rentals after the agreement to the undersigned, with the undersigned being Chad Lee, and the company there's a party to the credit application also being Superior Site Services, that this rental agreement, or excuse me, this credit application will control and govern all rental subsequent.
If I can interrupt, other than the language of the document, what in the record shows that the parties intended it to continue being the basis of their relationship?
Well, Your Honor, I think the best evidence is that there's nothing in the record to suggest that anybody did not intend this credit application to continue. And based on the language of the credit application and Florida law as it pertains to guarantees, it's clear that it's on the responsibility of the guarantor, or in the credit application's case, the undersigned, both instances being Chad Lee, to notify Herc that it's either been revoked or that there's been some change, in order to let Herc have the opportunity to also get the benefits of the terms and conditions of the rental agreement, just as he was getting benefit from the rentals.
So what, then, if you're looking at the plain language of this document, then it would have been up to Mr. Lee to say, oh, by the way, the entity that owns the fictitious name is now C. Lee Inc. in 2007, and then at some point, assuming that was acceptable to Herc, then at some point to notify Herc that there is no longer a C. Lee Inc., and there is no longer a fictitious name. But their argument, the point, and I think what Judge Maker's trying to point, is that there's a separate company involved. I know they have this similar, obviously, name. If the new company in 2015 was Big Dog Inc., and it was Mr. Lee and Mr. Pacheco knew each other, and Mr. Big Dog Inc. was doing business, grading business, et cetera, would he have been obligated to say, oh, by the way, I'm now doing business as Big Dog Inc., I'm no longer Superior Site Services? I mean, if the name is evident that it's a different entity, wouldn't that have triggered some obligation on the part of... In other words, he didn't have to tell you, I'm doing new business, the old business is dead, I'm now running a new business 5 years later. Why would he think that the guarantee would still apply to him 5 years later?
Well, Your Honor, I see I'm...
Go ahead,
out of
I
time,
asked you.
right? Your Honor,
Judge stuff, but,
this
be
is-
omnipotent here.
well, the guarantee is inextricably linked to the credit application, and all of the language in this 2006 credit application refer to the undersigned, with the undersigned being Chad Lee. So all of the responsibility is on him, even if the name were different, even if the business were different, to let Herc know that they're no longer doing business with the same entity so that they have the opportunity to reevaluate their credit. However, that isn't the case here.
He tells them I'm Big Dog Inc. now. That's my entity that I'm doing business. I'm Big Dog Inc. is now doing I'm in the grading business. I'm now introducing myself 5 years later, and he has to formally say, and oh, by the way, I formally revoke the guarantee from an entity that's been deceased for 5 years? Is that what you're arguing? Is that what you're saying here?
In a sense, Your Honor, I mean, as far as the credit application goes, again, it's important to note that Herc thought for the entire length of the business relationship that they were doing business with Superior Site Services, Inc.
And that wasn't very persuasive to the judge.
No, Your Honor, it apparently wasn't. However, she did find that that credit application formed the entirety of the business relationship between the parties. And so her finding, in a sense, cuts Herc's legs out from under it, because they've been relying on this credit application and the guarantee, and yet they won't, under her ruling, don't get the benefit of its terms, whereas Mr. Lee gets the benefits of the rentals. And for these reasons, Your Honor, the appellant respectfully requests you reverse the decision of the lower court.
All right, thank you, counsel.
Thank you.